This is BBC News, our top story. Donald Trump hails a victory after securing legal and constitutional backing for a key immigration policy, a travel ban on several mainly Muslim nations. Well, let's stay with that story now and speak to Michael Johns in Philadelphia. He's one of the founders of the National Tea Party movement and a former White House speechwriter in the George Bush Sr. administration. Michael, thanks so much for being with us. Very intrigued to hear your thoughts on this. Donald Trump obviously celebrating. This is a significant victory for him, but lots of critics already saying this is essentially a Muslim ban in all but name. What do you think of that?
Not a Muslim ban at all. The largest Muslim populated countries of the world were never included. Indonesia, Pakistan, India, Egypt, Bangladesh, all excluded. This is essentially pointed at a handful of countries that have been carefully reviewed, whose vetting processes for individuals entering the United States was deemed inadequate. And so in those cases, the president took, which is his entire authority to do under 1952 statute that empowers him to manage, the president to manage our visa programs, some sensible steps to restrict that immigration. And it is a suspension, not a termination, meaning if these countries do, in fact, make steps to improve their processes, it's entirely conceivable that you could see them removed from the travel ban list.
And it's interesting here, isn't it? The court obviously took a deliberately, narrow framing here. They chose to disregard Donald Trump's statements more widely in the campaign. For example, calling for a complete shutdown of Muslims entering the United States. But part of the problem here is the way this looks. You have a travel ban coming off the back of those kind of statements. That's what people are angry and upset about. You must see that.
Yeah, I mean, clearly, and it wouldn't be the first time that you see a rather significant deviation from campaign rhetoric to the actual, minutia of governance. And I think the court, which ruled 5-4, the 5 justices that ruled with the administration, I think properly looked at the order itself, compared it to the underlying statute that empowers the president to take the steps that he did, and concludes that, in fact, the president acted with complete legal authority. Now, interestingly, and this is more of an intellectual argument, assume, for instance, that the president had put in place a Muslim ban. If you look back on that 1952 statute, and this is something perhaps Congress wants to look at, there does not appear to be anything in there that precludes him from taking whatever steps he wishes to take from the standpoint of suspending entry to the United States. That includes, I think the phraseology is the suspension of alien groups or all aliens to the United States.
Well, that suggests there's a problem here in the legislation. That's surely a loophole that should be closed.
Well, if you feel that the president is unduly authorized to act in the national security interests of the United States of America, then you would want to see that more narrowly and perhaps more explicitly defined and written than it has been. And it seems to me that really that in essence really is the debate. It's not being phrased quite that way, but this has really become a debate over that 1952 statute. You cannot deny, and I think the court found it impossible to deny, that President Trump was fully authorized to act in the way that he has acted in restricting immigration and entry to the U.S. in these ways. Additionally, okay, I think the political dimension of it is that this was broadly popular with the American people who, Well,
you say it was broadly popular. There are a large amount of critics, of course, and we will be speaking to those again in the next hour. For now, though, Michael Johns, we must leave it there. Thank you very much for your time.